What's up, people? Supreme Decisions here, and I'm coming to you today with a tad bit more information. But today it's going to be a little different because I'm not going to give you Supreme Court cases. I'm going to give you something that was kind of eye-opening because I've said a few things in the past that's in regard to when a police officer can make an arrest. And generally, we spoke about evidence and evidence suppression and all that good stuff, but we never talked about the actual arrest itself. A lot of us take for granted that a police officer knows what they're doing and they have some sort of authority. But here's the power that I want to explain to you, because they are public servants. They work for the public interest. Now, if they ever tell you, I work for such and such police department, then they don't need to be wearing the badge because they actually work for the benefit of the public, because that's what they took their oath for. But just to give you the gist of it, because they don't have any authority until there's a crime, which means there's a complaining witness that had damage to person or property, because that's an injury that can be adjudicated. Now, today what I'm going to talk about is really simple, because you remember I also added in a third reason for them to be there, and that's them witnessing a felony. And generally a felony is excessive damage to person or property. Just to give you the scopes, here we go. The power of a criminal investigator to make an arrest depends on federal law. Why? Because that's the supreme law of the land. And that's what they are operating in, because you remember the Selective Incorporation Doctrine. Mens rea, actus rea, corpus delicti. That's what federal law is. That's what the Supremacy Clause is. That is what a law enforcement officer is to be operating in. Now, he possesses the same right as a private citizen to make an arrest, because remember, it's only damage to person, damage to property, not store theft. Keep that in mind when you're trying to tackle somebody and be a hero in the parking lot of Walmart. 1, they may arrest for a felony, damage to person, damage to property. 2, breach of the peace committed in his or her presence, because again, they have to witness it. They have to be first-hand recipients of it. They have to be an injured party to that effect, because they are there and they can give a first-hand account of the action that has transpired. And 3, and for a felony that is not committed in his or her presence, that felony in fact must have been committed, and he or she has reasonable cause to believe that the person arrested had committed that felony, which means someone can identify them. And that is where a lot of these cases get thrown out, because when you have cross identification or cross race identification, unfortunately, it's difficult for an unlike race to identify someone in a different race. It's science. Don't know why. It just is what it is. But one of those things will be considered a Wade hearing. And again, I'm going to get into that later. Now, I've also gone over exigent circumstances. And other than one of these, it is required for a warrant to be gotten by the officer. And basically, an arrest is the act of an offender being taken into custody, imposing restraint upon him or her with formal notification. Basically, them announcing that you're being arrested, or the show or display of a warrant for from a judge. A seizure, a forcible disposition of one person arrested. Now, a police officer cannot search unless they had either a search warrant or enough evidence to arrest the suspect and take him into custody. An arrest can only be done with probable cause of a crime. I'm going to go deeper into that, because that is the important part of any and every arrest. There has to be probable cause of a crime. No need in arguing with them. Take it to court, beat them in court, and then, just like I'm going to show you in a little while, they lose their qualified immunity by enforcing policy for the most part. doing a willful action against what I just said earlier depends upon federal law in which he or she as a law enforcement officer is operating. If they're doing any action against federal law, it is a willful act or an act of ignorance. Both of those, they lose qualified immunity. Keep that in mind. Those are the reasons for arrest. That is exactly what arrest is, and those are the stances that allow you to take your stance on whenever you're setting up the fight. Supreme decision. See you next time. When an illegal arrest is made, the officer involved waive their qualified immunity and are liable for damages done to the one arrested. Quarren v. Jordan, 440 U.S. 332, 1979. The reason that's important is because first we must understand the reason you were taken for arrest. And if it is not falling under those guidelines, this becomes applicable.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.